Wills are able to have trusts within them. These are called will trusts. At Honey Pro, we offer various types of will trusts at a click of a button. For this video, we are talking about a protective will property trust in particular. A protective will property trust, in short, a PWPT, isn't a single document in itself. Instead, it is a bundle of legal documents which have collective benefits to the testators of the documents. This bundle includes 2 wills, 2 lifetime interests, and a severance of tenancy. When these are combined, they provide an extra level of protection during the lifetime of, and after the death of each testator. Where more than one person within the UK owns a property, there are different ways in which these people can own it. If you live in England or Wales, people can own a property together as either joint tenants, or as tenants in common. Owning a property as joint tenants means that none of the co-owners can specify what their share is, because the owners all own the asset jointly. When someone passes away as a joint tenant, the property passes to the surviving owners automatically, through survivorship. Due to the fact that joint tenants don't have a specific share in the property, should one owner become bankrupt or come into debt, the whole home is in trouble. Owning a property as tenants in common means that those who own that property can quantify what their share is, whether it be 50%, 60%, 70% and so on. When a tenant in common passes away, their share is dealt with by their will, or intestacy, if there is no valid will. As a tenant in common, should you become bankrupt or come under any other debt, such as be indebted to care fees, then it is only your share of the home that can be considered to pay off your debt, not the share of your co-owner. This means that owning a property as tenants in common can help protect your other co-owner during your life and even after your death. The process of changing how you own a property from joint tenants to tenants in common is called a severance of tenancy. Once this process has been completed, each owner is free to deal with their share of the property however they wish through their own testamentary documents. By putting a protective will property trust in place, it allows your co-owner, who will be called the life tenant, to keep residing within your main property. In this type of trust, it lasts a lifetime, unless the life tenant wishes to revoke this benefit. The protective will property trust also has the added benefit that if the property is rented out at all, after the testator's death, the life tenant has the benefit of any and all income generated by the property. Of course, the prerequisite to these types of trust is that the testator must have owned a property, or a share of a property at the time of their death. Especially in the case of the protective will property trust, if the life tenant is a spouse and the property is being passed to direct descendants, this type of trust can also preserve the right to apply for the residential nil rate band allowance, which adds another £350,000 to a married couple or civil partner's nil rate band allowance. After death, the executors only need to simply transfer the legal ownership of the property into the names of the trustees, for them to manage on behalf of the life tenant.